Yesterday, you might have been legally allowed to buy a gun. Today, that same right could be gone, or expanded, depending on who you are. In a shocking 8-1 decision, the Supreme Court just redrew the line on who qualifies to own a firearm in America. And here's the part most people are missing. This isn't just about criminals or background checks. This ruling could affect ordinary people, people with past records, people under certain restrictions, even people who thought they were fully protected under the Second Amendment. So the real question is, did your rights just change without you even knowing it? Stay with me, because once you understand what this decision actually says, you'll see why this could impact millions of gun owners overnight. If you want to stay ahead of all major gun law changes, hit subscribe now. Don't miss a single update. To where this all began, the moment that led to this 6-3 decision, the foundation, the Bruin earthquake that shook everything. Before this 6-3 decision rocked the nation, there was another, one that started it all. The case no one thought would rewrite the entire playbook on gun rights. New York State Rifle and Pistol Association versus Bruin. June 23, 2022. Most people missed it, but inside America's legal system, the ground shifted. Because on that day, the Supreme Court didn't just rule on concealed carry permits in New York. It tore down decades of judicial reasoning in one breath. And what they replaced it with was a ticking bomb. For the first time ever, the court declared, the Second Amendment is not a government privilege, it's a constitutional guarantee, one that must be judged by history, not politics. Then came the real shocker, something lawyers now call the Bruin Standard. From that moment on, every single gun law in America had to be justified by historical tradition. If a modern restriction didn't have a historical twin from the 1700s or 1800s, it didn't belong. Imagine it, the entire U.S. gun control system suddenly standing trial against history itself. And here's the twist no one saw coming. Overnight, the burden of proof flipped. No longer did citizens have to prove their rights. The government now had to prove its limits. That's when the floodgates opened. From California to Delaware, lawsuits started pouring in. Thousands of pages citing Bruin as the sword that would cut through red tape. Courtrooms that once dismissed gun rights challenges began to stall, hesitate, and eventually, breakpoint one judge even wrote in his opinion, this ruling has set in motion a constitutional reckoning. He wasn't exaggerating, because every one of those cracks led straight here, to 2025, to the ruling that finally detonated what Bruin started. The decision that has lawmakers furious, and gun owners asking the same chilling question. If the Supreme Court just changed who can buy a gun, what happens next? To find that answer, we have to step inside one of those early battlegrounds, a small state with a big case, Delaware, where the first domino fell, and the path to the 6-3 decision truly began. Let's go there. Delaware. The first domino. It didn't start in Washington. It started in a small courtroom, Wilmington, Delaware. No cameras, no fanfare, just a handful of attorneys, a few reporters, and a law that was about to crumble. Delaware had passed a law restricting gun purchases for anyone under 21. Lawmakers said it was about safety, keeping firearms out of the hands of young adults. But the plaintiffs, two 20-year-old citizens, said something different. They said, if I'm old enough to vote, to pay taxes, They said, if I'm old enough to vote, to pay taxes, to serve in the military, why am I too young to defend myself? That single question, simple, honest, impossible to ignore, became the spark that lit the match. Their lawyers came armed with one weapon, the Bruin Standard. They argued there was no historical tradition, none, of banning 18 to 20-year-olds from owning firearms. And when the state tried to justify it with modern statistics and safety data, the judge stopped them cold. Under Bruin, he said, modern concerns cannot erase historical rights. The courtroom went silent, because in that moment, a state law fell. The judge ruled that Delaware's age restriction violated the Second Amendment. And just like that, one domino tipped over. But what no one realized was that Delaware's quiet decision wasn't the end of a fight. It was the beginning of a chain reaction. Other states took notice. California, Illinois, New York. Each one had similar restrictions. Each one suddenly looked vulnerable. And inside the Department of Justice, alarms started ringing. Federal lawyers warned that if these state laws kept falling, Entire sections of federal gun statutes could collapse next. And that's when the stakes exploded beyond Delaware. Because the government realized, if the Bruin test kept spreading, the very definition of who could buy a gun in America would be rewritten. And they weren't about to let that happen quietly. Behind closed doors, new cases began forming. Test cases designed to stop this movement in its tracks. But instead, one of them would do the opposite. IT would take the Bruin logic even further and force the Supreme Court to confront a question no one wanted answered. Who decides what's dangerous, the government or history itself? That battle began 3,000 miles away. In a state known for gun laws so strict, even the police struggle with the paperwork. California. The next battlefield in the war over who gets to buy a gun. California. The breaking point. California, where gun laws don't just regulate ownership. They regulate the idea of ownership. Every sale, every permit, every bullet, tracked, approved, and verified. To buy ammunition here, you don't just show ID. You go through a background check every single time. On paper, it sounds like safety. But in practice, it turned millions of law-abiding citizens into suspects. Imagine buying ammo for a weekend range trip and being flagged as prohibited because a database misspelled your name. That's exactly what happened. Thousands of legal gun owners suddenly failed background checks. Some waited weeks to be cleared. Others gave up completely. The system didn't just delay freedom, IT denied it, by design or by dysfunction. Then came a man named Kim Rhode, an Olympic gold medal shooter. She took California to court, arguing that the state had turned a constitutional right into a government-controlled privilege. Her case, Rhode versus Bonta, would become the legal powder keg everyone feared. And when the dust settled, the federal judge didn't mince words. He called the system unconstitutional, burdensome, and historically baseless. He cited Bruin directly, saying the state's laws had no historical analog. In other words, history didn't back California. And if history didn't back California, it might not back anyone. That ruling sent panic through anti-gun circles across the country. Because for the first time since Bruin, a state's gun control framework, not a single law, but an entire system, had been dismantled in court. Lawmakers scrambled. Appeals were filed within hours. And federal attorneys begged the Supreme Court to step in before the precedent spread. But the court didn't rush to stop it. They watched. They waited. Because behind the scenes, another case was moving toward them. One that wasn't about bullets or permits at all, but about blame. A case that would test whether gun manufacturers themselves could be punished for crimes they didn't commit. That case would drag not just a company, but the entire firearms industry into the fight. It's called Smith & Wesson versus Mexico. And when that one hit the docket, the Supreme Court could no longer stay silent. Smith & Wesson versus Mexico, the case that forced the Supreme Court's hand. When Mexico sued American gun manufacturers, most thought it was symbolic. But inside the courtroom, it became something far more dangerous. The case, Smith & Wesson versus Mexico, claimed U.S. gun makers were responsible for cartel violence south of the border, that their designs, marketing, and even advertisements fueled crime. If that argument succeeded, it wouldn't just target companies, it would tear through the foundation of the Second Amendment itself. Because if gun makers could be blamed for the actions of criminals, how long before gun owners could too? That question haunted the court. And when the Supreme Court finally ruled, 6-3, it wasn't just a verdict, it was a declaration. Liability cannot cross borders, not for companies, and not for constitutional rights. The decision sent a shockwave through the legal world. But buried deep in the majority opinion was a single paragraph, one that quietly redefined the limits of federal power over gun purchases in America. A paragraph that every lawmaker, every attorney, and every gun owner needs to read. And that's what we're revealing next.